In this video, I'm going to be talking about commercial general liability insurance. The majority of this information comes from the CPCU 552 text on risk management and commercial liability. This is from assignments 2 and 3. But again, you don't need to study the text in order to take the exam. All of the material is covered in this video and in the Prezi. Let's start by looking back at the components of a sample commercial insurance package policy. Remember that we've covered commercial property, commercial crime, commercial inland marine, equipment breakdown, and commercial auto. The last thing to cover is the commercial general liability form. A general description of commercial general liability insurance is that it's an ISO, Insurance Services Office form. The ISO CGL is the most common form used to provide general liability insurance to businesses. The American Association of Insurance Services also has a CGL form, but it's not nearly as commonly used, and a few insurers do develop their own independent forms. But again, the ISO CGL is the form that you'll run across most. There are coverages A, which is bodily injury and property damage liability, coverage B, personal and advertising injury liability, and coverage C, medical payments. We'll spend the majority of our time in this video discussing coverage A. So let's talk about coverage A, bodily injury and property damage liability. First, we'll look at the insuring agreement for coverage A, and then we'll look at coverage A exclusions. The Coverage A insuring agreement says we will pay those sums that the insured becomes legally obligated to pay as damages because of bodily injury or property damages to which this insurance applies. Let's first look at the definition of you versus insured. This is an excerpt from the text. Understanding the distinction between you and the insured is important because the terms are used throughout the CGL policy. You means the named insured shown in the declarations. The insured, for that matter, includes either the named insured or any other person or organization that qualifies as an insured under the Who is an Insured section of the policy. Employees of the named insured, for example, are insureds even though they are not individually named in the policy. The distinction truly can be crucial. For example, an exclusion of damage to property in the custody of the insured would apply to property in the custody of the person or organization qualifying as the insured and against whom a claim is made. But in contrast, an exclusion to damage to your property would only include the named insured. So, 3 things are required in the insuring agreement. First, the insured must be legally obligated. The damages must result from bodily injury or property damage, and the policy must apply to bodily injury or property damage. Let's look at each one of these individually. So again, these are general conditions imposed by the CGL Coverage A insuring agreement. First, the insured must be obligated by law to pay damages. Damages must be the proximate result of a type of legal wrong for which civil law provides a remedy, similar to what we discussed in the last video. This could be a tort or a breach of contract. The insurer may investigate, but they must establish that their insured is legally liable in court or by investigation. They also must establish that the policy covers the claim. With this first condition, there are 2 subconditions. The insured has to be legally liable, as proven by a court's decision or by the insurer's own investigation, and they must show that the policy does indeed cover the claim. Next, there must be damages for bodily injury or property damage. We'll talk about bodily injury first and then property damage. The meaning of bodily injury is actually subject to interpretation. Examples of bodily injury include loss of earnings and medical expenses, general damages for pain and suffering, and in some jurisdictions, punitive damages. Coverage might include care for mental injury or emotional distress, even in the absence of physical harm. Physical damage to tangible property, including loss of use, is covered, and consequential loss or loss of use of tangible property. Electronic data is not considered tangible property. It's actually excluded. However, the policy can be endorsed to cover electronic data. One comment about consequential loss. If, for example, the top floor of a building is damaged and the insured is liable, even if the bottom floor is completely untouched, if the whole building has to be destroyed because of ordinance or law, consequential loss to the bottom floor of the building would be covered under the insured's liability policy. Injury for which damage applies is a third condition. Coverage applies only if the insurer has established that the insured is legally liable and that the policy covers the loss, as I said before. The insuring agreement also states that the insurer may investigate any occurrence and settle any resulting suit, even if the insured doesn't want them to settle. Now let's look at a few more provisions of the insuring agreement that are imposed. Bodily injury or property damage must be caused by an occurrence as defined in the policy, and the occurrence must take place in the coverage territory during the policy period. And the named insured or any other insureds must not have been aware of the bodily injury or property damage before the policy began. Let's look at these a little more closely. So these are additional conditions imposed by the CGL Coverage A insuring agreement. First, let's look at caused by an occurrence. The policy provides coverage for any adverse condition that occurs over a long period of time and eventually results in bodily injury or property damage, as well as a sudden event that results in the same. So, for example, a loss could be caused by pollution that occurs and damages property or does bodily harm to another person over a long period of time, or it could be a sudden event like an explosion at a factory. The policy excludes intentionally caused losses, however, but it does cover bodily injury and property damage resulting from an intentional act if the result was unintentional, as we discussed in the last video. An example might be if a contractor is working on a building and the contractor uses a torch which starts a fire. Even though the starting of the fire may have been intentional, it certainly wasn't intended that it resulted in the damage to the property at large. However, if the act was an intentional act of arson, this of course would be excluded. Additionally, the occurrence must be in the coverage territory. This applies to the U.S. and territories, Puerto Rico, and Canada. You need to remember those three areas. It also applies to all parts of the world if two conditions are met. First, that the injury or damage must arise out of goods or products sold in those places I just named above, the U.S., its territories, Puerto Rico, and Canada. The activities of a person whose home is in those locations and away for a short time on the named insured's business, or personal and advertising injury that occur through the internet or similar electronic communications. The second condition, the insured's liability for damages must be determined in a settlement that the insurer agrees to or in a suit on the merits filed in the accepted locations I just mentioned above. So in other words, both of these two conditions must be met for the insured's liability to be covered anywhere in the world. In contrast to the CGL's worldwide products liability coverage, the coverage territory for completed operations is limited to the locations listed above, the U.S., its territory, Puerto Rico, and Canada. However, the completed operations coverage territory does include international waters. So, for example, work that was performed by a ship repairer in the U.S., if it malfunctions at sea, the resulting damage or injury would be covered. Now let's look at injury or damage during the policy period. The vast majority of CGL policies have an occurrence trigger. This is as opposed to a claims made trigger. While the textbook does have a section on claims made, because they're not really very popular or widely used, we won't even discuss claims made triggers. With an occurrence trigger, the bodily injury or property damage must occur during the policy period in order for coverage to apply. Let's look at an example of this. Let's look at 2012, 2016, and 2017. And our example will be an example of products liability. We'll start with when the product is manufactured. For example, an electric scooter. In 2012, Insurer A's policy was in effect. In 2016, the insurer changes policies, but this is the year when the injury occurs. A handlebar breaks off of the scooter and a child falls off the scooter and injures his knee. In 2016, Insurer B's policy is in effect. Then in 2017, the claim is actually made. The child gets surgery on his knee, and the family incurs significant medical bills, sues the scooter manufacturer, and the scooter manufacturer is deemed legally liable. At this time, Insurer C's policy is in effect. So, which policy covers this loss? The answer is, of course, Insurer B's policy. It was in effect when the accident occurred. While this can be fairly simple for the type of loss I just discussed, it can be problematic for some types of loss, especially losses that are caused by prolonged exposure, such as pollution damage and asbestosis, which is caused from long-term exposure to asbestos in ceilings and walls. It can be tricky at the time of loss to determine which policies are applicable. Courts have adopted a continuous trigger theory, which results in the stacking of limits of all of the policies applicable during the exposure and works to the benefit of the insured and sort of against the insurance companies. Now let's discuss injury or damage not known before the policy period. The CGL occurrence version contains wording aimed at eliminating coverage if the bodily injury or property damage was known to have occurred by designated employees or insureds before the policy inception date. This is known as the Montrose language. It was named Montrose language after the court decision in Montrose Chemical Corporation versus Admiral Insurance Company decision. From this court case, the court rejected the known loss rule that the insurance companies were trying to apply. This type of case often occurs when there is toxic waste or a chemical spill, and damage occurs over a long period of time that spans multiple policies. The known loss rule basic intent is to eliminate coverage for progressive injury or damage that spans multiple policy period, but begins before the current policy period began. And essentially, from the Montrose rule, the known loss rule that insurance companies have tried to apply has not been effective. In other words, insurance companies end up having to pay for liabilities that were known to their insureds, even when the damage, such as that from toxic waste, was known to insureds before the policy began. ISO has tried to modify this language, but some states still reject the known loss rule. And lastly, there's the insurer's duty to defend. In addition to stating their duty to pay damages, the CGL Coverage A Insuring Agreement expresses the insurer's right and duty to defend the insured, and as I said before, in some cases, to settle a claim even when the insured doesn't want them to. Now let's look at Coverage A exclusions. We'll start with exclusions with exceptions, and then we'll turn to exclusions without exceptions. But before we do, let's make a couple of observations. This is part of a quote from the textbook. The ISO CGL coverage form can take you on a journey with unexpected twists and turns, especially when negotiating the exclusion section. Several of the exclusions have exceptions, creating hairpin turns in what is excluded or not, before you figure out what coverage is actually provided under the form. I thought these were worth mentioning from the text because they do a pretty good job illustrating just how complicated the ISO CGL exclusions can make the policy. But let's first look at the purpose of these exclusions. The main cost driver in insurance is, of course, claims. Exclusions allow insurers to contour cost of claims estimates by excluding certain losses that aren't ideally insurable, such as catastrophic losses like pollution or war, and losses that are not fortuitous, in other words, not outside of the control of the insured, such as criminal acts, or insured elsewhere, such as workers' compensation or commercial auto. So let's now look at the exclusions with exceptions. With these exclusions, coverage is often excluded and then immediately provided with an exception. The exception to the exclusion is actually an acknowledgement of coverage. So in a way, the exclusions section has several statements of coverage. First, expected or intended injury. This is a really important exclusion for the insurance company because it substantially reduces moral hazard. In other words, insureds intentionally causing a loss for the purpose of collecting on insurance. Remember though, when the act is intentional but the result is not intentional, the loss can be covered. Another exception is when bodily injury is caused by the use of reasonable force to protect persons or property. For example, if a security guard tries to restrain an individual who's become violent against one of their customers and breaks a rib of the attacker, even though that was an intended injury, because it was a reasonable use of force to protect another person, it would not be excluded. Contractual liability. This can be challenging to interpret because of all of the definitions and exceptions. The exception to this provides coverage for contractual liability for liability that would have existed in the absence of the contract or agreement. The contractual liability exclusion does not preclude coverage for liability that is the basic intent of the policy. For example, because of a contractor's negligence, the roof of a building under construction caves and damages much of the property inside. Even though there was a contract between the contractor and the owner of the building, the damage to the property inside would be covered because the contractor was negligent. Additionally, liability assumed within an insured contract, which is a defined term in the policy, would be an exception. Let's look at some examples of that. Many of these relate to hold harmless agreements. First, a contract for lease of premises. This covers the insured's responsibility to indemnify a landlord for liability, such as premises liability for someone slipping and falling on the property. Coverage for liability associated with a sidetrack agreement, which covers losses from the hold harmless to the railroad. When a railroad builds a sidetrack to a business, which is often done in order to help bring goods and supplies to a business, especially a manufacturer, generally the railroad requires a hold harmless agreement to be signed by the business. Losses that occur related to this sidetrack agreement, where the business has to hold harmless the railroad, are covered under the liability policy. An easement or license agreement, which allows one party to have restricted use of another's property, usually holding the other party harmless, such as a pipeline that runs through the business's property, but the pipeline itself is not their property. If something happens to the pipeline, the business agrees to not hold liable the owner of the pipeline. An obligation to indemnify a municipality. This is again like a hold harmless agreement, which would say that the municipality is held harmless for its own actions, and therefore any liability that is assessed against the municipality has to be reimbursed by the business or insured. An elevator maintenance agreement. Commonly, when a business has an elevator in its building, they're responsible for the maintenance. So, for example, if an elevator malfunctioned, causing someone to be injured, and that injured party sued the elevator company could turn around and sue the business where the elevator is located, and they would be reimbursed by the business's commercial general liability policy. And then parts of other contracts under which you assume tort liability for another party, such as construction, sales, etc. And now let's look at the liquor liability exclusion. This excludes coverage for bodily injury or property damage liability for which the insured is held liable by causing or contributing to the intoxication of any person, which occurs by furnishing alcoholic beverages to a person under the legal drinking age or under the influence of alcohol, or through any statute or regulation relating to the distribution of alcoholic beverages. However, it only applies to businesses that are in the business of manufacturing, distributing, selling, or serving or furnishing alcoholic beverages. But that's not always that easy to determine. Take, for example, even a nonprofit organization that has a regular event like this Beef and Beer and Vendor Night. The event is a fundraising event, but because they are raising money and charging for beer, it requires a liquor license. This type of event would be excluded, and this was an actual case in Pennsylvania. Now let's look at the pollution liability exclusion. I took this diagram from the CPCU text, assignment 2, and it just shows how you would navigate the pollution exclusion and its exceptions. So it's split into 3 different types of insureds and exposures. First, on premises, owned, rented, or occupied. Then on non-owned, non-rented premises, or where an insured is performing operations. And then on premises that are used for the storage, testing, or detoxifying effects of pollutants. So let's look first at on premises, owned, rented, or occupied by the insured. If the pollution damage is caused by vapors from heating, cooling, or dehumidifying equipment, or heat or smoke or flames from a hostile fire, then that is covered. But if it's caused by some other type of pollution, it's excluded. So that's pretty straightforward. And I took a new picture here because that was a little bit fuzzy. So if it's on non-owned, non-rented premises or where the insured is performing operations, then another new picture. If it's caused by the release of pollutants from contractor operations on the premises of the owner, and the contractor never owned the property, and the contractor is the insured, then it is covered. If it's the escape of fluids used to operate mobile equipment, it's covered. If it's vapors from materials that are brought into the building by the insured for operations, that is covered. And if it's caused by a hostile fire, again, that is covered. But if it isn't one of these 4 things, then it's an excluded cause of loss. If it's on a non-owned, non-rented premises or where the insured is performing operations. And then lastly, for the on-premises used for storage, testing, or detoxifying effects. And this is a little fuzzy too, but it was just a short section. It is actually excluded, but cleanup or testing as required by authorities is actually covered under the policy. Now let's look at employer's liability. Remember that even though workers' compensation is the exclusive remedy for employee-related injuries, an employer liability might arise. For example, when the employer is negligent in some other capacity besides employer and injures the employee. This is actually known as the dual capacity doctrine. These types of losses are covered by coverage B in a workers' compensation policy, as we discussed in the last assignment. Employer's liability is excluded unless the employer assumes legal liability by a hold harmless agreement with a third party, so similar to contractual liability. Aircraft, auto, or watercraft exclusions. Coverage is excluded for liability arising out of the ownership, maintenance, use, entrustment to others, or loading or unloading of any aircraft, auto, or watercraft owned by, rented to, or loaned to any insured. The purpose is to defer to other insuring forms. In other words, aviation insurance, ocean marine insurance, and of course commercial or personal auto. There are some exceptions though to this exclusion. If it is owned or rented watercraft ashore, if it's non-owned watercraft less than 26 feet long and not used to carry people or property for a charge, if an insured is parking a non-owned or non-rented auto adjacent to the insured's premises, this doesn't cover the vehicle being driven. As an example, say a valet is parking someone's car, and when they come into the parking garage, they actually hit the garage and another vehicle. The CGL would not cover the property damage to the car that they were actually driving, but it would cover the property damage to the garage and to the other vehicle. Also, an exception is the assumption of liability under an insured contract for the ownership, maintenance, or use of an aircraft or watercraft, not auto, and the operation of machinery or equipment attached to what otherwise would be considered an auto. Now let's look at the damage to property exclusion. And again, we'll look at this diagram from the CPCU text that helps to explain it. So first of all, let's say that the insured leases the second floor of a 2-story building. Coverage for damage to the portion of the building rented to the insured is provided for fire subject to the limit of insurance. The property in care of the insured is excluded. Remember that the insured is leasing, but coverage for damage to the portion of the building rented to the insured is provided. Additionally, liability coverage is provided for damage to the portion of the landlord's building that is not rented to the insured, down here. Next, real or personal property owned by the insured is excluded. So if the insured owns a building, that is not covered under the CGL. It would be covered under Commercial Property Policies, BPP. Liability coverage for damage to real property on which the insured is working is provided if such damaged portion is not that particular part on which the insured is working. And last, the insured sold a building to MF Corporation. Property damage to premises sold by the insured to this other corporation is excluded. The exclusion, however, does not apply to liability for contractor's work if the contractor did not occupy or rent the building. Now, 4 more exclusions with exceptions. Mobile equipment, damage to your product and damage to your work, damage to impaired property or property not physically injured, and recall of products, work, or impaired property are all excluded, but with exceptions. Now we'll look at exclusions without exceptions. Workers' compensation, war, personal and advertising injury, which are covered in the next part, electronic data, and the distribution of material in violation of statutes. Now let's look at coverage B, personal and advertising injury. This pays those sums that an insured becomes legally obligated to pay and agrees to defend the insured for damages arising out of these 7 things. First, false arrest, detention, or imprisonment. Malicious prosecution, which is when someone files a case against the insured under false pretenses. Wrongful eviction, wrongful entry, or invasion of a right of privacy to a room or in a room. Slander, oral, or libel, which is written, publication that disparages a person's or organization's reputation, goods, products, or services. Oral or written publication that violates a person's right of privacy. The use of another's advertising idea on one's advertisement. An example of this can be found at this website, where actually Arby's has a commercial about hamburgers, and McDonald's commercial seems suspiciously similar to Arby's commercial. However, Arby's has not decided to sue. And copyright or trademark infringement. This is an interesting quote from clickandcopyright.com's blog. It says, "The internet has changed the world of intellectual property law irrevocably. However, this is not to say that intellectual property law has kept up with the times. Far from it. The ease with which you might casually infringe on someone's copyright makes policing infringement a rapidly ballooning problem." So therefore, this is a very complex area, and I think going to be a significant problem for insurers over the next several years and decades. A couple more points about personal and advertising injury. It includes coverage for mental anguish or injury, fright, shock, humiliation, and loss of reputation, but it's not actually limited to these. It excludes coverage for a knowing violation of the rights of another and material published with knowledge of falsity. Material published prior to the policy period, criminal acts, contractual liability, and electronic chat rooms or bulletin boards. There are some other exclusions, but this is enough for our purposes. Last, let's look at Coverage C, medical payments. Coverage C, medical expenses include coverage for first aid administered at the time of an accident, necessary medical, surgical, x-ray, and dental services, including prosthetic devices, necessary ambulance, hospital, professional nursing, and funeral services. This is not liability insurance. In other words, the negligence of the insured is not a factor in determining coverage. It provides a way of settling minor injury cases without the determination of legal liability. It can be excluded by endorsement if the insured doesn't feel they want it, but it is a great way of eliminating the need to defend yourself when you think you're not negligent and to eliminate the escalation of smaller cases. And that's the end of our discussion of the commercial general liability policy.